Cove Productions presents the Solo in South Philly podcast with your host and local legal whiz, with knowledge, Mark Kachi.
What's good, everybody? We are back with season 2 of the Solo in South Philly podcast. Season 2 is called I Need a Lawyer. I will be speaking to lawyers that I reach out to when I need information or advice. Today's guest is David Bigelow. David Bigelow is a personal injury, wrongful death, and workers' compensation attorney at the law firm McCann, Dillon, Jaffe Lamb. He was born and raised in South Jersey and currently lives in Delaware County with his wife, Regina. David earned his undergraduate degree at the University of Tennessee and his JD at Rutgers Law School. After law school, he clerked for a judge in Philadelphia County Court of Common Pleas. After his clerkship, he worked for a large law firm defending commercial insurance carriers and self-insured corporations in civil claims for injuries and property damages. Thereafter, David switched sides and joined his current firm where he represents the little guy, making civil claims. David handles claims ranging from a simple rear-end car accident to more complicated workplace accidents and incidents involving defective products resulting in catastrophic injury and death. He's licensed to practice law in state and federal courts of Pennsylvania, New Jersey, and Maryland. His firm's Wilmington, Delaware office also serves clients in the state of Delaware. All right, let's welcome David Bigelow to the program.
Thank you, Mark. Thanks for having me.
Thanks for joining. Glad to have you on to talk about workers' compensation law. How'd you get into that area?
So I was wanted to be went to law school. Decided I want to be a civil lawyer. Went to work for the insurance companies for a couple of years, and then I jumped over to the plaintiff side, the little guy side, the worker side, and got involved. It really started with third party claims, but given we're in that injury space, you do workers' comp as well, and that's what we're here to talk about today. But I really started in the kind of the third party world. Now on the plaintiff side, representing the average Joe, the daily person injured on the job, and the comp world, the third party world are so intertwined. It's almost if you do one, you do the other. So that got me into that world, and happy to talk about workers' compensation and specific to Pennsylvania, and then some generic, broad issues on that topic today.
Great. So workers' compensation, what does that mean? What does it entail? Let's start general. Yeah, absolutely. So little history lesson I prepared today. So every state has a workers' comp statute. As of about 1949, every state in the United States had a workers' comp statute, and it's a no-fault system. The first no-fault system goes back to Germany in the late 19th century. Essentially, no fault means that if the person's injured, they're covered, they're compensated no matter what, no matter whether they cause the accident, somebody else caused the accident. It's a system to make people whole. And I guess the public policy reason was, people getting injured on the job. It's tough to prove liability in a third party context. So they created this no fault system to basically make people whole who are injured on the workplace. So think about coal miners, factory workers going back to the early 20th century. That's kind of I think states and the federal government reacted to those subset of people, sustaining injuries and maybe not able to receive compensation in the third party context. So they created the no fault system, or they adopted the no fault system that was really modeled in Europe first. But essentially comp is it's to make you whole, and to get a no fault a little more, you can cause the accident, still be basically recover be compensated for the injuries. For example, you're a bus driver, you rear end somebody, you hurt your neck, you're out of work. You caused the accident, but the fact that you're within the course and scope of your employment makes you eligible for benefits. And the trade-off is, you get the benefits from your employer, no questions asked. But the trade-off is you cannot make a direct claim against your employer in the context of a third-party claim. So you're precluded from making a direct claim against your employer, but in exchange for that waiving that right to sue, you're in the comp system, and every state has a comp system that's governed by that state-specific workers' comp statute. Right. So to give some context, the way I see this, I view it as one of the great compromises of all times. You talked about waiving your rights against a certain party, but tale as old as time. People get injured at work. If there were no workers' comp system procedure in play, people could sue their employer, and as far as damages goes, there's an assortment of damages that you deal with in the personal injury world, right? So what we've done here is we said, look, we've enacted these laws. I believe each state has their own law, but the overarching concept is the same. And the compromise is, look, employee, we're not going to inquire into fault so much, right? If you were injured on the job and then the injury is holding you back, you're going to be compensated for it. But the compromise is that, your damages are going to be limited to how the law provides it. And like you said, the intention is to make that employee whole. So would you agree that's a good assessment of what this system is?
Yeah, absolutely. And I think the reason they put it in was it was very difficult for injured workers to recover in a third party context because they have to deal with, right, common law defenses, assumption of the risk, all that. There's a whole body of law, right, for tort stuff about affirmative defenses. And a lot of these employers, I think, were successful in defending the third party claims because sometimes, right, jobs are inherently dangerous. If you're climbing skyscrapers, there's a chance you could, right, that something could happen. So there's a lot of pushback, and this kind of leveled the playing field, right, for the injured worker, the employer, and it does, right, like you said, makes you whole. But it is also limited damages, right? You can only recover a certain amount of damages, and we could jump to that now if you'd like.
Just one more thing I do want to add in terms of an overarching concept. So, and again, correct me if I'm wrong. So what's happening here is the employers, these companies, as a cost of doing business, they're required to purchase workers' compensation insurance, right?
Yep.
And when these claims for workers' comp injuries are being pursued, it is the insurance carrier, that company, that is coming in and then paying the party out. It's not that employee is suing employer, absent insurance, and they're going to court. It's all taking place through against an insurance company and through the procedures outlined by the law, correct?
That's correct, right. So if you want to do business, right, for example, the state of Pennsylvania, Commonwealth of Pennsylvania, if you want to do business in the Commonwealth, you have to register with the Comp Bureau, the Secretary of State, and you have to have that comp insurance, right? And there's different limits, but everyone right there has a limit. And essentially, you are right, correct. You're covered by that comp policy, and it's not the employer who's paying out or making the claim. The employer pays the insurance company a premium, and then the insurance company has, right, a team of adjusters and claims people that handle the claim. They accept it to deny it. That is one thing I think that maybe people don't know is a lot of comp cases don't even go to court, right? The comp courts or administrative court, the majority of comp cases are just handled between the parties. You make the claim, the insurance company accepts it, denies it, and you go from there. Really, when the attorney gets involved is when the claim is denied, and then you have to go to the workers' comp judge, the administrative court, and have a judge decide the case. Because, right, we all know insurance companies are in the business of making the business of making money. They want to maximize premiums, minimize what they're paying out in claims. So they're incentivized to defend every claim. They hire doctors, they hire lawyers to minimize and deflect and do everything they need to do. And that's where you have the plaintiff's bar, right? What I do, we kind of push back on that, and we are able to bring the injured party's case to court and have a judge look at it and have a judge make the decision, right, per the Pennsylvania law, per the workers' comp statute, as to what is compensable, right, for that work injury.
Perfect. Okay. And what did you say you wanted to get into?
So I was going to talk a little bit about what is compensable in a comp case. So we just talked about how really the first kind of hoop to get over is, right, injured on the job, right? And then, I guess I'll start with that. So on the job, within the course and scope of your employment, right? So that means pretty much anything you can arguably relate to the job. I mean, the big one you see sometimes is when there's a whole body of case law about what is and what isn't, right, within the course and scope. For example, right, driving to work, driving to your job to clock in, that's not within your course and scope. But if your employer says, hey, I want you to take the truck down and pick up some materials, bring it back to the job site, you mean while you're on the clock, that is within the course and scope. So it's really fact specific what you're doing. Like if you're on your lunch break, you're not going to be within your course and scope. But if you're doing the work, you're being directed by your boss, directed by somebody at the company, you're going to make arguments. Your lawyer's going to make arguments that you were within the course and scope, and more than not, the judge is going to find that make that determination, which will entitle you to benefits, right? So there really are, I guess, two kind of three main ways to get compensated in Pennsylvania, at least for workers' comp injuries, and the two main things you get paid back are lost wages, right? The wages you missed due to the injury, and then medical bills, right? Accident-related medical bills. So those are the two big ones. A lot of people they think work injury, right? Oh, you have a lawsuit. That's not necessarily true. You might have a lawsuit against someone else, but not your employer, right? You're only going to get the lost wages and the medical bills. And some of the injuries that are covered by the comp statute, right, would be, right, obviously workplace accidents, specific incidents. So, for example, right, you're working on a job site, something falls off the crane, hits you in the head, right? That's a work accident that'll be covered, right? Another one is repetitive activity. So my father was a subcontractor. He did ceilings and drywall in Philadelphia for 30 years, and he would have carpenters make comp claims. His drywall carpenters, who would be pushing the drill with their shoulder, right, for after years, put drill and eventually they tear the rotator cuff, make a comp claim. That repetitive work injury, right, that's something that will be covered. Some people don't realize that. Some people think there has to be some very dramatic accident for you to have a work-related injury, but those kind of things, repetitive injuries, even carpal tunnel, if you're a writer or you're typing, or in the office setting, that will be something that's covered. Repetitive injuries, specific incidents, and then the last one is pre-existing conditions that are aggravated by your work. So if you have asthma and you're in a workplace where you're breathing in fumes that might affect your asthma, the fact that you have a pre-existing condition is not going to prevent you from being compensated. That will play in as long as there's stuff that you have to prove it. Obviously, you have to have a doctor back it up. But it's not just the workplace accident; it's those repetitive injuries. It's the the aggravation of pre-existing conditions. And then other long-term disabilities, and we get a little more fact-specific, but those are kind of the large, broad strokes. And as to compensation, right, you would get accident-related medical bills, right? So you go to the doctor, they send a bill, the comp carrier is going to pay a large amount of that treatment before it goes to your private health insurance. And then as to wages, you'll get somewhere around 2/3 of what your regular wages are. You're not going to get the full 100%, unfortunately, and that's per statute. The statute's long. It has kind of a calculation, right, of how you get your wages. And another one that people don't realize, you can get compensation for specific loss or disfigurement. So, for example, you have a scar on your face, or you lose a pinky, right, or you reach your hand in the machine, you lose a finger. There's a whole chart in the statute that says, hey, this is how much almost each body part's worth. It's kind of morbid. I mean, it's kind of hard to believe you put a number on things like that, but that's the way it goes in the comp world. It doesn't mean you can still get money on top of that in the third party world. You make a claim somewhere else, but the comp world, you're limited to the loss, 2/3 of the lost wages, the medical bills, and then any specific loss you can prove, right, according to the statute.
Okay, great. So yeah, this underlying philosophy, what it sounds like you're saying is you're an employee, you go to work, something happens at work that causes you to get injured. As a result of this injury, now what's happening is A, you're missing work, right? B, you may have out-of-pocket expenses because you're having to go to the doctor to fix that. So what the system does says, okay, you missed work. Here's some money to make you whole in that realm. And here is some medical expenses to help you out in that realm. And, we don't live in a perfect world where we can put the toothpaste back in the tube, but this is the court's way of making this individual whole for an injury sustained at the job. Absolutely right. And like you said, it is a great compromise, right? Without the system, you might not have people willing to go into certain fields, right? I mean, they're jobs that are inherently dangerous. And without a system like this, you'd be basically putting the burden on the average citizen, right? To have their own insurance, to take their own precaution. I mean, there's a lot you're putting on the little guy as opposed to the corporation, the people who are paying taxes to the Commonwealth. It is a trade-off, and I think it really started with the mid-19th or 20th century rather. People being taken advantage of, people getting hurt, dead, killed, deceased, disfigured, and really having no recourse. And a lot of people would file third-party claims, and they'd lose just because the negligence common law wasn't there, and there's a lot of roadblocks you have to deal with. But the comp system, the default is taken out.
the fact that you're within the course and scope, you're now automatically entitled to compensation. And essentially, it's a question of how much compensation. And that's really what the issues that are litigated, right, when you go to a workers' comp case, right? So, for example, right, we're in a workplace accident, you're injured, they accept the injury, no problem. You're treating, you're seeing the doctors. All of a sudden, 3 months go by. The comp carrier says, "Well, we think you've healed." They might even have you come in to see one of their own doctors who's going to write a report and say, "Oh, we saw Mr. So-and-so and he's fine. He can go back to work." The injured person might disagree. They might even have their own doctor who says, no, they have to be out another year. They can't go back to work. But the insurance company, like I said before, right, they want to minimize what they're paying out. So they're about to incentivize the hired lawyers and doctors to cut off those benefits. And what they'll do is they'll file a petition, go to the comp judge and say, "Hey, listen, here's our medical opinions. We believe that Mr. So-and-so, right, has reached his improvement. And he can go back to work, whether it's for us or somebody else. We want to terminate benefits." And that's when you really need a lawyer, right? So before that happens, the lawyer's kind of there, almost like kind of holding your hand, walking you through the process, make sure you have all the paperwork filled out and you have the right documents from the comp carrier. But the heavy lifting the lawyer does happens when they try to take you off or they try to modify your benefits. They might try to knock your wages down. They might say, "Oh, you're older now. You wouldn't get paid that much. I mean, your earnings went down." There's 100 reasons for them to knock your or try to modify your benefits. So those are the big litigated issues, and that's where we get involved right in our office. We would either respond to the petition, file our own petition, and you basically get a hearing with an administrative judge. A lot of them are on Zoom now. They used to be all in person, right? You go down to the comp room. It's kind of like a whole little event for the lawyers, but it's all Zoom now, which is fine. But that's kind of the litigated issues are those, and they depose doctors. They take statements from the injured parties, just so you win a third party case. So, that's the litigation side. We can talk more about that maybe down the road.
Yeah, let's go back to cover a couple things. One, you talked about the injuries. One thing you didn't mention, which I'm guessing is acceptable. What about stress? Job-induced stress and health issues that flow from that, heart attacks or blood pressure or things of that nature. Can those be qualified workers' comp claim?
If it meets the statute and you can get a doctor, right, to back it up, right, I mean, you can always make the claim and it's going to be up to the judge to decide. So that's a little more case specific. But you do hear cases like that, right? PTSD, kind of major stuff with real treatment. You can't just say, "Oh, I'm anxious now." You have to have it backed up. You have to have it documented, taking prescriptions, right? Kind of have a paper trail, some more evidence to just your word, right, to make that kind of fly. Well, you do see that, but largely comp claims are limited to you think, right, blue collar jobs, right? The majority, right, workplace accidents, construction workers, carpenters, plumbers, that kind of stuff. That's probably the meat of the comp world. But you do see stuff like that. Even, right, people don't realize this, but NFL football players, right, if you're injured in a game or a practice, you're entitled to workers' comp. There's players who are retired for 30 years are still collecting comp today. Mm-hmm. So there are other, right, compensable, classifications out there, but the big ones are, right, those blue collar, hard hat jobs.
Okay. And, we talked about fault being off the table for the most part, but that doesn't mean the litigation goes away because they just move the battles to the other areas. So a couple areas that I assume get litigated all the time is, were you at work? So I don't mean that in this easy sense, like, were you at the factory when this injury was sustained? But you kind of talked about that. People who drive to work, they're not within their scope of they're not considered on the job at that point. But you do have people that have flexibility in their jobs, right? Mm-hmm. So maybe someone's job is to go to a bunch of sites over a course of a day. Maybe someone's in pharmaceutical sales, right? And they're going from venue to venue. And these are things that can get litigated, right? Because there's distinctions as to were you on the job or close enough to what your job lets you do? Or, were you frolicking and, going to Topgolf and having a few beers and playing golf and on the clock and then, hurt yourself?
Right. You might technically, right, between 9 and 5, you're technically on the clock, but is what you're doing really work related, right? That's where I guess the question. And that's the determination the comp judge would make if the parties can't agree, right? Usually if the parties agree, the claim's accepted, it's paid out. If not, that's when you litigate those issues. And they're right. There's case law. There's decisions on what is within the course and scope, what is not within the course and scope. The big one, right, on the way to work, definitely not. But if you're going out for, I mean, even arguably maybe on lunch break as well. But if you're, I think the biggest thing, at least you always see, is if you're directed by, if your boss tells you to do something, go pick up this up, or you're in sales, right? You're bouncing from location to location. That's just an inherent part of your job. So it's going to be hard for the insurance carrier to argue you're not within your course and scope. If you're a salesperson who visits, right, 7 sites a day and checks in on this and that, I mean, that's right, square within the course and scope of your employment. So it is case by case, right, very fact specific. And you need an attorney sometimes, right, to pull those facts out, to develop that record, to bring the evidence to the court. And a lot of times the courts, they kind of, I don't want to say they defer to the injured worker, but they're there kind of looking out, right, for the citizens of the Commonwealth. And those judges I think they're appointed by the state, by the governor at some point. But it's an administrative court. It's not a traditional courtroom you'd think with a jury and all that. It's a little more streamlined, and it's very formulaic, right? There's numbers and charts in the statute and the petitions, right? The templates. It's very template driven, the practice. And that's why I see a lot of these firms who do high volume workers' comp, because it's the same thing over and over again. I mean, once you do it once, you kind of know how to run it. And at my firm, we do third party income. And the reason we do that is because most times when you have a third party claim, you have a comp claim, or vice versa. You have a comp claim, you have a third party claim. So we can run them both in house here, and we can talk a little bit more about that at the end. But they're very intertwined, right? And but they have different kind of legal pitfalls, and that's why it's a good reason to have a lawyer involved. I mean, if you are injured at work.
Yeah. And then another distinction that comes up is work versus horseplay, right? So in this scenario, you're maybe at work, no question there. You got injured, no question there. But it could get litigated that was what the act you were doing considered somewhat related to your job, or were you completely acting a fool and therefore not entitled to it?
Right. Yeah. If you're right, horseplay, right. Absolutely right. If you're throwing the football around, or right, you can think of 100 or 1,000 scenarios where that arguably could be out of, I guess, the course of scope of your employment.
Let me throw a real life example an employee told me about, and I could definitely see the argument on both sides. So he worked at a Foot Locker, and an employee friend of his was being dumb, and instead of using a ladder to grab some shoes that were a little high up, tried to show off and jump as high as he can and grab the shoes, and he fell and he got some pretty bad injuries. So one, he was helped by the fact that fault is not, at issue there. So there's no contributory negligence or any of these kinds of arguments. But the question is that within his scope of employment, or is that horseplay? What do you think?
I would say, yeah. I mean, if he's getting the shoes for a customer or for his, supervisor, it's hard to argue he wouldn't. I'm sure you could find some comp carrier and some defense attorney who would take the other position. But yeah, I would take the position, right, that you're definitely trying to deliver something to the customer. You're a sales agent. You're grabbing a product to display or distribute to a potential customer. Whether how you got there is irrelevant given the no fault analysis. Yeah. So I think that would be covered. But obviously, right, every case is fact specific, and we'd have to flesh it out a little more. But.
And in this case, it ended up working in his favor. I think whoever decided whether it even got fully litigated, but you're right. Like the fact that he was in the process of doing something work related, like his judgment was obviously not good, but he was doing it. He didn't go about it the right way, but it was therefore within the scope of employment. And this guy, for doing something silly, received his benefits.
Yeah, and and even just other facts, the fact that he's at the place of work, right? He's wearing their shirt with their decal. He's got their stuff on. Maybe he has a smartphone where he's reading people out. The facts that they have, the gear with them, the equipment. There's just more arguments to say you're within your course and scope. I could think of other facts that take them the other way, but stuff like that does matter as well at the store. The fact that you're doing it for a customer, I think that would be the biggest one. But that's an interesting scenario.
Okay, and then let's talk about another thing. Let's say there's no questions there. You're at work, you get injured. But there's a duty on the employee to notify their employer. Is that correct?
Yeah, absolutely. Right. So you can't just have the injury and not tell anybody. Yeah. So my advice is report it as soon as possible. Go get checked out by a doctor. It's always better, even if you don't think, right, oh, well, I don't know, I'm not sure if it's going to be really going to linger. How's this going to affect me? It's always good just to get in within 24, 48 hours and have someone look at you, run the diagnostic testing, make sure there's nothing more internal that you're missing. So going back to treatment, well, I guess something I do want to say, and you kind of reminded me what that question was, right, treating for a work injury. So you want to report it, you want to go see a doctor. Often, most times, the comp care is going to direct you to one of their doctors, and you're going to have to go see them for a certain amount of time. I think it's 90 days. That's written down earlier. Yeah, but basically, you have to go see their doctor for, I believe it's 90 days, and I'll confirm that. Basically, to go see their comp doctor, they're going to have a list of doctors for you to see, and unfortunately, that's just the way that the act goes. But once you get over that 90-day period, that's when you can go see any doctor you want, and the comp carrier will still pay for it, right? So the first 90 days, it's their doctor. They get the right to choose. If you're still injured, you're still having issues past that 90 days, that's when you're free to go on your own, and they have to still pay those benefits, assuming that the claim has been accepted. And that's when you see them start to modify, right? When the 90 days runs, now you're at your new doctor. Maybe your new doctor is recommending treatment they don't think you should be having, and they might come back and try to modify the notice of compensation. And that's when the litigation, kind of the heavy lifting works. And that's why, another good point to have a lawyer.
Okay. So the duty of the employee is to notify the employer, and then the duty of the employer is to notify the insurance company. Is that correct?
That's correct. Yeah. So they got to turn around and call their comp carrier. And at that point, it's kind of like the employer's hands off. They're like, hey, we want to take care of you. Go to our comp people. They'll handle it. And then, the insurance company can be the kind of the bad guy. You know what I mean? It's because you want your employee to be taken care of, obviously. And I think it's a tough line to toe for the employer if they had to continue that relationship with their employee, right? And also be the person being like, hey, we want to cut you off, we want to modify. So, and the expense rate on the employer would just be so burdensome for every work injury to do all that, which is the reason they have insurance, which is the reason the statute, makes you have insurance. So it all goes through the insurance company, and they essentially make a determination out of court. They accept it. And then if they deny it, that's when you go to the comp judge, you file your petition, and then you get listed, and the court will decide what's compensable. And basically, you basically have the issue decided. You go back to the carrier, you work it out. Something else arises, you go back to the court, they decide it. You go back to the carrier. So it's kind of ping ponging back and forth between dealing with the claims people and then going to the court to kind of fix the problems.
Now, with regard to timing, we talked about the easy ones where it happened on the job, everyone saw it, you can see the blood gushing, you can see the broken bone, whatever. What if the injury is latent? So what if you're some coal miner and the company got theirs out of you, they got the labor out of you, and then you develop black lung or something years later? Can you go back and file a workers' comp claim, or how does that work?
There's time bars there, so it would be I guess a little more case specific, but depending on the injury. But you see that sometimes, right? Asbestos claims. I know you can't make a claim for your employer on that; it's all third party. But largely, I think those latent kind of 20 years later, that's going to be more in the context of a third party or a mass tort claim. The workers' comp, it's got to, not all the times, but more than not, it's, you know what I mean? It's that specific incident. It's that repetitive injury. It's the aggravation of the pre-existing, the latent, disabilities or issues that come out 20 years later, people working in a coal mine, or like you mentioned. Unfortunately, those more likely than not don't fall within the comp world. There are always exceptions in the statute and the case laws. One of those things that are evolving. But I think you'd be more stuck with what's closer in time. And if you had something like that latent, that'd be more addressed more in a third party claim, assuming you could prove it and pursue it against a viable defendant.
Okay. Now you mentioned this a lot. Why don't we educate the audience what this is? You talked about third party claims. So in this situation, parties 1 and 2 are employer employee. Who in these scenarios are third parties, and why are we going after them?
Right. So the context we see a lot, right? So for example, workplace accident. So employee works for a subcontractor. He's a carpenter. Something bad happens. Someone falls off a crane, falls on him. He gets hurt. You make your claim with your employer, right? and they pay your lost wages, your medical benefits, any specific loss. You also have a third-party claim against the other subcontractor who operated the crane, right, and dropped the anvil on top of you. You might also have a claim against, right, the other subcontractors who had involvement with whatever that work being performed is done. You can also have a claim against, right, inspection people, the property owner. So there's a whole, another arena of people that you can make claims against. And I don't want to say the best case, but the more lucrative cases, right, in that kind of context, are where somewhere you can make the comp claim against your employer and then turn around and make third-party claims against the GC, the general contractor, the other subs, the inspection people, the property owner. And that's where you get your pain and suffering, right? Your future medical, your pain and suffering. And those, when you see these big verdicts in the newspaper or on TV, those are all driven by pain and suffering, right? That's pain and suffering is whatever the jury is willing to award, right, for your duress and your injuries. And it's very, very case specific. And those are why third-party claims have value, why third-party claims settle, because they don't want a jury to determine, right, what the number is going to be. They'd rather just pick a number and everyone agree on it. So in the context of the first party, right, so we call for workers' comp's a first party claim. You're making a claim with your insurance or your employer's insurance. You're going to get the wage loss. You're going to get the medical benefits. You do that, and then you turn around and make the third party claim against basically any other potentially liable parties. A lot of times you just sue everyone and kind of let them kind of work their way out. And eventually, after discovery is done, it narrows down to these three entities are really the primarily liable parties. And then you settle the case with them. Something people don't realize, though, when you make a third-party claim, all the money that's paid out by the comp carrier is now they basically have a subrogation right on your third-party claim. So they pay out $100K for your medical and your wage loss. You turn around and sue all the general contractors and the property owner and get $1 million. You now have to pay that $100K back out of the $1 million, not the full $100K. Usually we can work it down. But technically, right, the comp carrier has a subrogation right on the third-party claim because they're going to say, well, if somebody else is taking responsibility for causing these injuries, why are we paying out $100K for medical benefits and wage loss? We should get something back too. And often the attorneys, at least in my practice, what we do is we submit the comp lien as part of the case. It's evaluated by the third-party insurance company who's going to pay to settle the case. We settle the case, and then we call up the comp carrier and say, hey, can you take half of what the balance is, or a third or 2/3, and you work it down. And more often than not, they're willing to cut it down because they don't want to litigate the issue. They kind of want to recover as much as they can and move on to the next one because they're paying so much out in claims. If they can keep stuff coming in on subrogation, it kind of helps their business model, right? Given the right, maximize the premiums, maximize what's coming in, minimize what's being paid out. So that is kind of a wrinkle people don't realize, right? When you have a comp lien like that, you do have to pay some of it back, but it also gives your third-party claim, a good amount of value because the jury's going to hear at trial that he has $100,000, right? He's got to pay back to his comp people, right, for insurance. They're not going to talk about insurance, but they're going to hear that number, and that number is going to be factored into their award. So if you have a high comp lien, it does drive some value in the third-party claim context, and they are very, very right interrelated. That's why it's nice to have an attorney like the attorneys in my office who handle both and kind of navigate both worlds instead of having two attorneys, a comp attorney and a third-party attorney. It's possible, and you see it sometimes, but we like to kind of keep them together, have the same right office running both, just so we're not missing anything in it, and we can effectively handle both of the claims.
Right. Yeah, and I mean the wrinkle you said yes, but theoretically it's to avoid the party suing from getting paid twice.
Yep, exactly right. Double compensation, right? That's exactly it.
And again, so these third-party claims, they may have such value in the sense that the workers' comp is relatively easy to forecast, right? You're paid a certain amount. There's caps at certain amount. Time is finite, right? But then these other aspects of the third-party claims, which are happening outside of the workers' comp realm in civil court, things like pain and suffering and loss of consortium and these sorts of concepts, there isn't necessarily a formula. So, juries can get emotional and say, how do you put a price on one of these things? And then the amount that they award could dwarf significantly all those lost wages that you had claiming against your employer.
Absolutely right, and it really depends on what kind of case you put on, what the jury's like. It really is right, right, case by case, and depends what kind of jurisdiction you're in. Right? If you're here in Philadelphia, you'd be definitely willing to make a third party claim. I mean, juries give out good numbers in Philly, and it's a very pro plaintiff, pro injured worker kind of jurisdiction. Counties outside of Philadelphia, maybe in the middle of the state, are the opposite, right? They don't appreciate. They not a lot of people have understanding of big numbers, and they're a little more conservative, right? Where they always say the juries in Philadelphia are a little more liberal and willing to kind of give big awards. And I feel like, frankly, just the trial bar in Philadelphia is very, very high quality. There's a lot of really good trial lawyers in Philadelphia. That's why I see all these really big numbers. Combination of the juries, the skill and expertise of the lawyers. It comes together for some big numbers. But you're right. The pain and suffering drives it. You never know what a jury's going to do. If the jury really likes the plaintiff, they're more willing to give them money. If they don't like the defendant, they know there's some big corporation, make a ton of money. People bring their inherent biases in all the time, and you're supposed to keep them out. But it doesn't always shake out that way. And the jury system isn't perfect, but it's the best system we got, right? And we've made it this far. That's getting in the third party world. But you're right. I feel like a lot of people don't. When a work injury happens, they think, I have one or the other. Oftentimes you have both, right? So it's a good reason to consult with a lawyer to find out if there's a viable third-party claim, because you're not getting right. Comp's going to make you whole on the wages and the medical bills, but you're not getting any money for that anguish, right? That distress, that inconvenience that the work injury caused. You mentioned loss of consortium. You could bring a claim for a spouse, right? In the third-party context, in comp, there's none of that, and it is very formulaic, right? It's 2/3 of the wages. There are specific calculations for a body part. So, for example, my friend, he worked in high school. He worked at Home Depot. Like a pallet of a concrete mix fell down, pretty much squished the tip of his pinky, and he was in New Jersey. The comp law is a little different, but he was basically getting a settlement. He calls me up. I think I was in law, or this might have been in college. So I was in law school at this point. Calls me up and goes like, "Is this right? Like they're going to pay me this much for like my tip of my pinky?" And I'm like, yeah, that's what the statute says. I know it's kind of morbid. It's hard to believe that number is what the tip of your pinky is worth, right? But that's just the way it is. And there was no third party claim there because he was just at the Home Depot by himself, moving stuff. So unfortunately, he was just stuck with that amount. And that's something else I wanted to get into a little bit, kind of shifting gears. But like, how does a comp case end, right? Because people who basically you take the claim, you get awarded the compensation, and now you're out of work for the rest of your life, for example, right? You're going to get the 2/3 of the wages up until whatever, 65 or 67, whenever you're planning on retiring.
Is there a cap on the 2/3?
Yeah, there is, depending on, right. I think it has to do with time as well. But what I was going to get to was, a lot of the times these insurance companies, instead of letting you sit there and recover wages for 30 years until you turn 65, they'll basically do a lump sum payment up front and say, we're going to terminate the benefits in exchange for X amount payout. And that's kind of when your attorney would come in and negotiate something that would get you that same amount paid over 30 years. You can get it up front in a lump sum and agree not to basically pursue the comp case. A lot of people will do that, resolve the case, and then they might go get a job where they sit at a desk or do something a little less physically demanding, so you can continue to still work, right? Because if you're going to stay in the comp system and collect benefits, you can't go get a new job. You know what I mean? Because if your other employer finds out you're working somewhere else, they're going to cut it, right? Terminate your benefits for sure. So oftentimes, the case ends in kind of that lump sum payment. Otherwise, some people like to have the residual coming in at X amount per month, X amount per week kind of thing. So it depends on the plaintiff, the client, and the amounts, obviously.
Yeah, and one of the benefits of the lump sum payment, if you're getting paid $1,000, a month today versus 30 years from now, getting that money up front allows you to adjust for the present value and potentially invest that money, or at least have it now and spend it on what that $1,000 buys you today, as opposed to what it'll buy you 30 years from now.
Right. Absolutely. Right. No, that's true.
So let's talk about the pay. It's 2/3 of your pay and no taxes, correct?
Yes.
So no taxes come out of that. And
no tax rate. Yep.
And is it true that if you were prudent and purchased your own insurance, something like Aflac that you always hear on TV, that doesn't factor in? So you wouldn't forfeit any of your benefits. So someone who's prudent enough to purchase their own insurance, if they're injured on the job, can actually be sitting pretty when those workers' comp checks come in.
That's right. So that'll almost be stacked on top. And I think Aflac, a lot of these companies like that, they kind of sell themselves as we're there to bridge the gap, right, from that 2/3 to 100 to plus, right? Maybe you have your kids going to school, you got more expenses, people growing up, you have that kind of that buffer. So you're right. You could make other disability claims, short-term, long-term, or private disability insurance, and that's on top of the comp benefits you're already receiving.
Okay. And let's talk about something else. You talked about, this settling and out of work for life, but what about people returning to work, right? My understanding is in situations, well, one, if you go back to work, you're back to work, that's great. But there's times when maybe somebody needs to be eased back into it. So there's situations where they go back to work, maybe they're on light duty, maybe they work a little less, and then workers' comp actually bridges the gap in terms of the money that they would have got paid had they never got injured versus what they're making now because they're working less.
Right. No, that's right. So, for example, if you were doing a more hands-on, more intensive role, making $25 an hour, and now the injury happens, you go through treatment, you're able to come back, but now you have to do more of a secondary role, and you're only making 15. Right, comp would cover that difference as long as it depends how long going forward, but you would get that difference to start. Eventually, they try to modify it, and there's different reasons too, and to kind of end it. But basically, I guess the main argument is that basically they're back to health, they're back to full health, and they could go back to the $25 job. But you're going to have your own doctors, your own lawyers are going to push back and say, no, they're still stuck at the 15 job. They can only do so much. But as time goes by, you're going to get back to full strength. Most people will, right, eventually, depending on the injuries. But yeah, you're right. Comp can cover that gap, right? That I guess loss of earning capacity, if you want to call it, right? That's how we refer to it. But that is true, and you see that a lot, right? People go back for modified duty, go back for light duty. They're making less. Maybe they can't do overtime anymore. They were doing overtime consistently. You can show that for the 6 months before the work accident, he was working 60 hours a week, earning this much, and now he can only do 35 a week. You can have a judge award money for that, and the comp carrier is more likely not going to fight you on that. But the court's going to come in and do what they have to do. The evidence there, and if your attorney can present it that way.
Now, let me ask you this: why should someone hire an attorney, and when should someone hire an attorney when we're dealing with workers' comp?
So why, right? Because if you want to make a claim like this, you have to have a skilled professional, right, guiding you through it. A lot of times, insurance companies will, when they know people are unrepresented, right, they're going to nickel and dime you. They're going to try to get the case moved over, basically done and closed as fast as they can for a minimum amount. The attorney is going to bring that wealth of experience, right? They know what a case is worth. They know how to navigate those pitfalls. So you're
let me stop you right there, because I should have asked this as well. But would you argue that the procedure itself is inherently confusing to a stranger, even to an attorney? Like if you went to an attorney friend of yours that practices bird law, right? Are they going to be able to just pick up a book and navigate this, or does it take some understanding of the procedure?
Yeah, definitely. It takes some understanding of the procedure. It is, like you said, formulaic. It's kind of archaic because it goes back to the original statute passed, right, whatever year it was. Probably over 50 years ago, and it's changed, it's amended as we move forward in time. But you're right; it is kind of very formulaic, and it's not right. It's not something that's easy to pick up, but it is something once you learn how to do it, you pick it up, you can repeat it over and over again because it's the same, right? 5-6 steps, or maybe not that simple. Maybe I'm simplifying it too much, but it's one of those things. Once you figure it out, you know it. So unless you're on your 7th work injury and you know the whole deal, it's probably worth hiring a lawyer. Another reason would be to explore those third-party claims, right? Because we know the comp claims made, but oftentimes the lawyer is going to have the resources, the knowledge, the investigators, the kind of that skill and expertise to go in and do an investigation, to get the OSHA file, to find out what other government entities are involved and who they're pointing the finger at, and explore those third-party claims, right? Because they can, and that's the other thing, they can charge a higher fee on a third-party claim. The attorney's fees on a comp claim are right around 20%, and I think that's by statute. Whereas in the third party world, most attorneys charge anywhere from a third to 40%. And that's because they're spending more money and time and effort to investigate and litigate those claims, but they have more value. And obviously the plaintiff's bar is incentivized to make those cases right, to make money. And that's kind of the pushback, right? So that's the great part about the plaintiff's bar. You're kind of fighting for the little guy, pushing back against these insurance companies, making people whole, and making some money in the meantime, kind of thing. So it is lucrative in that sense. But going back to what you said about why it's important to hire an attorney, right? I think the main reason is just to navigate the archaic, the kind of the old school framework was the first reason. And then two is to explore for those third party claims, because you might be leaving something on the table and experienced attorneys going to be able to say, hey, we have more than just a comp claim here.
Yeah, you brought up a very good point. I didn't even think about that sure, the procedure, but even someone fully aware of their rights, knows they got injured, knows that they have a bona fide claim, knows that they're going to get adequately compensated. They may not see that, oh, well, I was standing on a ladder and the ladder broke and that caused the injury, and maybe the ladder was defective, or I was driving and maybe there's a products liability issue with the car, and they're staring at a slice of the pie and there's this massive remainder of the pie that's out there for them that a clever attorney can help them navigate and get them something that they wouldn't have got otherwise.
You're absolutely right. And that's exactly it. Right. Yeah. You said that's good analogy, the pie. Or if you're looking at the good picture, right, you're focused on the one corner where there's a whole avenue and another world of potential recovery out there. And right. Oftentimes these people are really seriously injured, right? They're entitled to be compensated for that pain and suffering, right? For that future anguish and all the mental stuff they're going to go through, stuff that's not compensated in the comp world, right? Just really bills and wages. Whereas in third party, you get those intangible things. And and that's why there's such a developed plaintiff's bar, because there's a lot out there. And you'd be shocked at how many accidents happen. It's amazing. I mean, I hear stuff new every day, and it's like, wow, it's hard to believe all that stuff's going on out there. But work injuries happen a lot, especially in Philadelphia. I mean, you got a lot of union workers, a lot of people on construction sites. There's a lot of firms that really make their bread and butter doing workplace accidents. Some of them just do third party, some of them do comp, some do both. Like my firm, we do both, and it's great. Every case is different, and my advice, obviously, I'm an attorney, as are you, but you're better off working with a lawyer, just to so you don't miss that 90% of the pie.
And let's talk about your fee for a second, because this is where your world is in some ways it's nicer to be in your world as opposed to mine. So a lot of people are scared of even calling attorneys because attorneys charge them, or once the retainer is signed, like, hey, I'm paying this much for every email, and I'm scared to even ask a question because they're going to charge me their hourly rate at however long I talk to them. But you talked about the 10-20%. We're talking about a contingency fee for that percentage. Is that correct? And if you could maybe explain how that works.
Yeah, correct. So in comp, right, I think the max you can charge, and I think it's pretty sure it's by statute, is 20%. And that will apply to basically, so you get $1,000 in benefits from the and this is if it's litigated, right? Because you can still get comp benefits without hiring an attorney, without going to court. You make the claim, they accept it, they pay it for a certain period of time. Eventually, they're going to try to modify it. And that's often when, unfortunately, people usually call a lawyer at that point. Hey, they're modifying, they're trying to terminate me. Can you help me out? It's better to have the lawyer involved from day one so you can investigate those third-party claims. But a lot of times they don't get involved until it's modified, or they attempt to modify it. So at that point, the attorney would come in, they file a petition, they basically defend the modification, and then they keep that $1,000 a month going. And now the insurance company would send an $800 check to the injured person, a $200 check to the law firm, right? 80-20 every time it goes out. And that's the statutory fee in the comp side, right? In the third party world, it's a little more fast and loose with the numbers. It's really whatever the parties agree to. The industry standard you see nowadays is anywhere from 1/3 to 33 1/3 to 40%. And in the third party, really in both contexts, the law firm's fronting all the costs. They're going to hire the doctors. They're going to do the investigation. They're going to do all the paperwork, all the filing, all the mailing, and nothing's out of pocket, right, for the injured person. You do sometimes have to pay the cost back, especially in a third party context. The law firm will take the fee. the costs, and then the client will be left with the lion's share of the settlement or the verdict. So that does factor in. But yeah, there's nothing out of pocket. Contingency fee, it's all contingent on us recovering money for the injured person. And like I said, we front all the costs, and that's how, 99% of law firms who do this work, that's how they do it. As opposed to someone in your world, right, billing an hour, like you said, people are reluctant. We get calls all the time. Oh, is this going to cost me anything? And I have to explain to them, absolutely not. No, it's totally, nothing out of pocket. As long as you agree to basically pay the fee at the end of the case, there's nothing there. And usually people have no problem doing that. It's just cost effective.
So you get paid only when they get paid, and therefore your interests are completely aligned, right?
Absolutely.
You want to get paid, so you want to win. You want to get paid the most, so you want to get them the most. Right. Your interests are completely aligned. My world, believe it or not, contingency fees for family law, for criminal law, they're not even allowed, right? Because they don't want attorneys trying to prolong litigation and ensure victory. They want to encourage settlements. So not really allowed to bill potential clients that way. And I have to explain that sometimes that, I'm sorry, you got to pay by the hour.
Right. Yeah. And unfortunately, that's just the way it goes sometimes. But at least in my world, we're a little more affordable for the average Joe. And it's all about that inherent value that these claims have, especially in a jurisdiction like Philadelphia County. Especially in the third party world. But it incentivizes the plaintiff's bar, to protect people's civil rights. And that's what we're trying to do at the end of the day, right? We're seeking justice. We're trying to protect people, make people whole. And like you said, right, the interests are aligned. The attorney's trying to get as much money as they can because their fee is going to be higher, if they get more. So it's kind of the best of both worlds for both the lawyer, the injured party, and I guess the public in general.
Okay. Now let's talk about some myths. What are some myths or misunderstandings or misconceptions about the realm of workers' compensation?
I feel like that that you don't have a claim that this won't fall under comp, or this isn't enough kind of thing, or it wasn't minor. I feel like a lot of times you see people who are like, I'm not sure if that's something I could do.
Let me ask you a couple that I come to mind.
There you go.
If you're getting paid under the table, can you collect workers' comp?
It depends. Sometimes you can argue that they're a statutory employer, and there's a whole body of law of whether a statutory employer would pay comp. But oftentimes they don't have comp insurance. If you're getting paid under the table, right, the comp carrier is not going to accept any claims. Even if they had a comp carrier, they have their 10 employees, but they're paying two under the table. The comp carrier is not going to pick those two claims up. But there is a fund, like a workers' compensation fund, that is in place for circumstances like that, where people are working under the table. You can make a claim with that fund. And a lot of times the fund will go after the employer on the back end and try to get made whole. So there is kind of like a safety net almost that the state operates. And I know that there's one in Pennsylvania. There's definitely one in New Jersey as well. I would venture a guess and say most states have that kind of safety net. And that's kind of a whole nother, I don't want to say an administrative world, but another kind of subset of the administrative courts and another claims process you have to go through with them. So we do see stuff like that, right? Statutory employers, you're technically not on the books. You're getting paid under the table. A lot of times you see that in the context of a third-party claim. When someone's injured, we make a third-party claim. They'll come back and say, we're the statutory employer. But then you push back and say you never pay any comp benefits, and it kind of doesn't land as what they'd like. But no, you do see that sometimes. But there are those kind of safety nets for people in those circumstances.
What about if you're an undocumented immigrant? So you're here, you don't have a valid visa, you don't have a green card, you don't have citizenship. You're working, but you don't have Social Security. So you're working not under the table because you have an ITIN and your wages are being reported, and there are withholdings. Can that individual claim workers' comp?
I would have to double check, but I don't think you can in the Pennsylvania system. There might be certain states where you can, but my understanding is to be limited to just a third-party claim in that context, right? And you can make a third-party claim as an undocumented person in Pennsylvania. We see it all the time. But I think you have to be a resident. There's probably a certain qualification of what qualifies you for the comp system, right? Because it's all driven by that one statute. So I'd probably have to double check, but based on what I'm going to tell you right now, I think that's a no, and you'd be basically stuck with a third party claim, which at the end of the day, you might still be made whole. It's just a different way to get there.
Okay. And then you mentioned this earlier. This is something I always like to talk about is the NFL, right? I have this like running list of, I guess a running list of things that they're topics that we always hear about in the news. And I feel like there's always information missing. One good example is, and you kind of alluded to that earlier, and I've had an attorney bring that up, that, there's insurance companies that are really funding the defense of a defendant in a civil lawsuit. And the jury doesn't know that. And if the jury did know that, it might impact how they think of these things. Right. So the NFL, we often hear times that players back in the day had all these injuries and they're made out to be, these people that are on the street and homeless. But many of them are eligible for workers' comp and are indeed receiving workers' comp. Is that correct?
Yeah, I mean, if they don't cut it off, like I said, you could have it in perpetuity. What's that word I'm looking for? I'm looking for
perpetuity.
Perpetuity. Yeah, thank you for that. Yeah, I guess until you retire. I mean, it's all age specific and time specific, really. But the one you hear in the news a lot is the CTE, right? The brain stuff for NFL players. Mm-hmm. There have been a couple cases where they're trying to get that basically to fall under the state workers' comp statute. I think in Minnesota, there's a Supreme Court case that said it did not fall under it, but I thought they filed something in federal court to try to undo that. So I think that issue is still kind of open. But that kind of goes back to the latent, the latent disability, something that you might not experience or realize until 30 years later. But my understanding is as long as you have the doctors can back it up and say it's related, it happened during this time period when they were working on the job. A court can, kind of not change the law, but decide that does fall under, right? Because the courts are just interpreting the law, the facts of the law, and then saying whether this falls under the statute. And I'd have to do a little more research, but I'm pretty sure there is active federal cases about the CTE stuff going on right now.
Yeah, that's a very interesting topic, and to my understanding, the ultimate latent injury, because if I'm not mistaken, you can't confirm it until the individual has passed away and there's an autopsy performed on them.
Yeah, no, that's something I need to think about. You're right. Yeah, especially, it depends what the diagnosis is. You'd think you'd be able to diagnose some things, but you're right. Probably a lot you don't know until you're doing the autopsy or studying the brain. And I think that's why we're seeing all that come out, because we're having players who, we're playing, in the 40s, 50s, 60s, or who now getting to that point where they're passing away. And now they're doing all this research and realizing, oh, wow, maybe there was a little more here than meets the eye.
Mm-hmm. All right. So as Andy Reid used to always say, the time is yours. Why don't you promote whatever you would like to promote?
Yeah, absolutely. Thanks. So thanks again, Mark, for having me on. I know we've been talking about doing this for a while, so I was looking forward to this, and I'm glad we were able to chat about comp today. But I just want to maybe fill in the audience a little bit more about me. My name's David Bigelow. I'm an attorney at the law firm McCann, Dillon, Jaffe Lamb. We do anywhere from personal injury, wrongful death, workers' comp, anything kind of in that world, the negligence world, right? Anyone with insurance, you got damages, they have insurance, we can make the claim kind of thing. And my office handles both third party and workers' comp claims in Pennsylvania, New Jersey, Delaware, and Maryland. I'm licensed to practice in Pennsylvania, New Jersey, and Maryland. And we try to do stuff like this to educate people. A lot of people don't realize, right, when work injury happens, like I said before, you might have more than one claim. So doing stuff like this, kind of getting that information out there is a good way to educate people on their civil rights. And I'm glad you had me on today. But, God forbid if something were to happen to you or a loved one, if you ever need to talk to a lawyer, I would be a great person to contact. My email is dbigelow, DBIGELOW @McCanninjurylaw.com. McCann is spelled MCCANN. And then you can always call or text me at 267-819-0351. So that's kind of my shameless self promo. But Yes, that's what we do. We do it every day. We do it over and over again. We're pretty good at it. We get good results. And we have an office in Philadelphia and Wilmington. We serve a lot of people in Delaware, Maryland border, obviously Pennsylvania, New Jersey. So we're more than just the Philly law firm, and we kind of sell ourselves as that kind of mid-Atlantic kind of firm. So, yeah, God forbid anything were to happen, family or friend, please reach out to me or Mark. We'll be able to help you out. And that's what I have to say about that.
Great, thank you. And I will put that contact information in the show notes as well, in case anyone just looks at it. They can go to your website or find your email address or phone number.
Right. Or even if they wanted to just had a question about comp, I'm always willing to talk to people. I feel like in my business, it's very reactionary, right? People ask me all the time, how can I prevent something like this? And just be careful. Unfortunately, we get called in, right, when something bad happens, and it's kind of pick up the pieces, make the person whole. So that is the business. But doing stuff like this, right, kind of educating people on their rights and talking these things out are also part of it.
All right, David, it was always a pleasure to talk about any areas of the law. I appreciate you coming in and talking about workers' comp, which a lot of people, I feel, we don't learn it in law school. So appreciate the time. And to all my listeners, stay solid and subscribe to my podcast.
Thanks, Mark. I appreciate it.
Need a lawyer? Are you having financial, criminal, or family challenges? Call or text the Mark Kachi Law Firm, 215-439-7899.